The only takeaway that I can offer for people who do this work or who may be in a little bit of trouble is ask for fucking diversion. We
Yes,
don't we
always.
don't do it. We don't ask for it a lot, either because I think maybe lawyers don't know it's a thing because it's so goddamn
Yes,
rare,
they don't.
or because they just think, oh, well, I'll never get that. You're never going to know until you try. And if you tell a good story around it and make a good case for it and do your homework, you will get it. I've gotten
Yes.
diversion in 2 cases in the last 2 years. Okay, so is that a lot? No, but I've asked for it in many, many other cases. And sometimes I get it and sometimes I don't. But let me tell you something. If it's good enough for Hunter, it's good enough for you.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you from the home studio, Scottsdale, Arizona. Here we are getting set for sentencing. Mark Allenbaugh, I love you to pieces. You're such a good friend and you're my most favorite colleague. But I was really hoping to be done with you for a while, to be honest. Like we've been talking, we've been like Trump and Walt
Yes.
and I don't know. There's been so much going on that we really just had to do kind of spur of the moment, timely. This is current. Let's do
Yeah.
this. And then I said, okay, well, we got now to done. Now I'm going to move on because I have a couple other, pretty interesting people that I've been
Yes,
talking
you
to
do. You
besides
do.
you. Um, and I've got these podcasts ready to drop. But then, God damn it, today, as the day we're recording this, which is June 20th, 2023, Little Doug Trivia, my 25th wedding anniversary today.
Oh,
Um,
congratulations.
I thank you very much. Anyway, I would say hi to Rachel, but we're not live. So anyway, and she doesn't listen to this podcast. She hates it. No, I'm just kidding. Anyway, today was the day that the news broke that Hunter Biden has is entered into a plea agreement with the federal government
Yep.
on couple of tax cases and some diversion and a diversion on a gun charge. And so we had to get back together, get the band back together one last time to talk about this because it's big. And so that's
Yes.
what we're going to do. And as usual, we're going to go over guidelines. What he's pleading to, which are these 2 misdemeanor tax counts. We're going to talk about diversion, which is what's happening on that gun charge, and that gun charge is worth talking about what it is
Yep.
and what it could have been, and diversion is worth talking about, whether that's rare, whether that's common, whether that seems like equal treatment or different treatment for Hunter Biden. And we're going to talk about what do we think, some predictions about what the end result is going to be. We don't have to do presumption of innocence here because the news broke that he's pleading guilty. So technically, he's still innocent, presumed innocent under the law until he goes into court and pleads guilty. But it's different than Trump, who's been just charged in an indictment. An indictment is not evidence of guilt. Hunter Biden has said, yeah, I'm guilty and I'm going to go into court and I'm going to plead guilty. So we're going to talk about all of it and more. So let us do that right now and tell me, generally, we know that the plea agreement has basically got 3 components, right? 2 misdemeanor tax and then a diversion. So let's dig in. We know that he's pleading guilty to these tax counts. What does that mean for him for a sentencing guidelines calculation?
Well, so first of all, he's pleading to 2 misdemeanors. So
Yes.
right there, good for him.
Yes.
Because with a misdemeanor, he's not going to lose his right to bear arms.
Yeah, he can still have a gun.
He could still have a gun.
Not on diversion, I'm guessing,
But
but
yes, not on diversion, and there may be other agreements in the plea agreement where he may agree to give up his right to own a firearm or something like that. I don't know. The plea agreement hasn't been filed yet. But at any rate, so it's two misdemeanor counts, which generally are very good. He's also not going to lose his right to vote.
Well,
So all the
sit on
collateral,
a jury.
I'm sorry, or sit on a jury.
Or
Yes.
sit on a
So
jury.
all the collateral consequences that come from pleading guilty to a felony or being found guilty of a felony are not going to attach here.
Yeah.
Now, they could, jumping over just quickly for a second, to the gun charge, which he hasn't pled guilty to yet, because then that's the point of the pretrial diversion. He's going to have more reason now to successfully complete that pretrial diversion to avoid that felony.
Yeah.
But at any rate, so with the two misdemeanors, each misdemeanor carries up to 1 year in prison. That's the statutory maximum for both. So the total time in prison that he's looking at is 2 years. As we've discussed before, every time you have multiple counts, the overall statutory maximum that a defendant is looking at, or what they're exposed to, at least in theory, is the just take all the statutory maximum of each count of conviction and you add it up. So here he's looking at a total of 2 years. He'll be sentenced under 2T 1.1, the sentencing guideline for tax offenses. Now, what's really interesting, though, is just like with fraud cases, with tax cases, the primary driver of the sentence is loss. But for tax cases, it's tax loss, which is a bit of a different animal. And it's a bit of a different animal than fraud loss. And it also has a different tax table. Now, what's also interesting, though, about tax loss cases or tax cases in general is, unlike in fraud cases, if you're charged with a fraud and there's loss in there, generally speaking, any interest or penalties, stuff like that with respect to the fraud, regular fraud, that is not added into the total loss amount for purposes of punishment or for purposes of determining the guideline range. Tax is different. Tax, you can get that added in if you willfully fail to file a tax return. If you willfully fail to disclose to the government or to pay that particular income tax also that's due on the tax return that you failed to file. So if you willfully fail to file that and pay the tax, then the interest and penalties are lumped into the overall loss for purposes of calculating the guideline range. And that could be significant here because in the information that he's pleading guilty to, he agrees that for 2017 and 2018, the tax loss was over $100,000 for each of those years. Now, he's not agreeing that it's just $100,000. He says it's in excess of $100,000. Now, that's all fine and good because $200,000, it's going to keep him within a particular loss range. As long as he could stay between $100,000 and $250,000 in tax loss, which again, for his purposes, is the amount that was owed that he didn't pay, he's going to start at an offense level of 16. But if he gets over that $250,000, and it looks like it's likely because the interest and penalties are going to be added in, even though he's already paid, according to reports, he's already paid all the tax and all the penalties and everything else that was owed, and good for him because that stopped the meter on the interest and penalties. But nonetheless, the interest and penalties that he already did pay, along with the back tax, all that's going to be added up by the probation office to determine his guideline range. And that likely, I think, is going to be over $250,000. If it's over $250,000, instead of a 16, he's going to start at an 18. And that can be significant because, as I'm going to go through with this, if he started at a 16, he may have ended up down at an offense level of, well, let's just start there. So let's say he starts out at 16. If he could keep his tax loss under $250,000, then he's going to get 3 levels off for acceptance of responsibility.
And by the way, that's an interesting number because when we've not talked about that, but there's a bubble on the
Mhm.
guidelines. So everyone gets a certain number levels off when they plead guilty if they accept responsibility, and it's usually
Yes.
going to be 2 or 3, and the cutoff is 16. So if your
Correct.
guideline is 16 or higher, offense level 16 or higher, you get 3 levels. And
Correct.
so if he came out of 15, he'd get only 2 levels or anything lower. So
Correct.
that's good. So he drops
Yeah.
to a 13, and then what?
So, and then what? And this goes back to, you'll have to plug in our episode number. I can't remember which one
The
it was.
Zippo.
The Zippo.
We're talking about
correct.
the Zippo, baby, which is the
So
0-point offender, the brand new sentencing provision in the guidelines that almost certainly goes into effect on November 1, and
yes.
that's retroactive and people are starting to make use of right now,
Yes.
says what?
Well, the Zippo says the 0-point offender downward adjustment says that if you have 0 criminal history points and you meet a number of other criteria, one of which, by the way, is that you did not possess a gun in connection with the offense. And let's just post that and hold that there for a second.
Yeah.
Then you qualify for an additional 2 levels off of your offense level. So we said we started at a 16. He's going to drop 3 for acceptance of responsibility. So now he's at 13. He's going to get another 2 off, which takes him down to 11.
Yeah.
And at an offense level 11, the guideline range is 8 to 14 months. However, he is in what's called Zone B. And this is kind of old school guidelines talk, but at Zone B, technically speaking, a sentence of imprisonment isn't even required. A judge can just give him a combination of home confinement and maybe a halfway house or something along those lines, and
so
skip imprisonment altogether.
3. Okay, so 3 follow-up points real quick. One is the Zippo episode is episode 53. So I'll put that link in the show notes if you want to know more about 0-point offender. For if you've got a case right now, you should be looking at that.
Yes.
2, even though there are a whole list of things that would exclude you from that.
Criterion 7 says
right.
If you possessed a gun in connection with the offense, then you are ineligible for Zippo. You don't get the 2 points off.
And so this is where the lawyers do the whole dancing on the head of a pin routine, because the question is this tax crime?
Right.
Did he possess that gun in connection with the tax offense? Because a good lawyer is going to hopefully stipulate this away in a plea agreement, but at the very least argue that the gun had nothing to do with his ability or motivation to commit a tax crime. It's two totally, there's no connection. It's 2 totally separate things. Therefore, there's no exclusion. Therefore, the Zippo should apply and you should get 2 levels. So you'll have to stay tuned to see if that's even becomes an issue in the case. But it's just sort of the rigmarole and the mental masturbation that we have to go through with every single one of these guideline, provisions. Sometimes nothing is ever totally. It's super simple, right?
Right.
So anyway, okay. So
he's at an 11. He's at an 11 with tax, but that is assuming he doesn't get over $250,000 in loss. If he gets over $250,000 in loss, then he starts at an 18, minus 3 for acceptance gets him to a 15, minus 2 now gets him to a 13, minus 2 for the Zippo gets him to a 13. And instead of looking at no time, because he would be in Zone B, he's now in Zone C, and that's 12 to 18 months. Now, that bottom range, if you're in Zone C, you only the court. Does not constitute a variance. Would be a within guideline sentence. The court would only have to give him 6 months imprisonment, and then the other 6 months, like on home confinement or something like that, or a halfway house. To comply with the guidelines. That would be a within guideline sentence. Now, Frank, as it turns out, a lot of the zone talk is, like I was saying before, kind of old school. This was like pre-Booker stuff. Now that the guidelines are advisory, basically courts are giving downward variances, and even in Zone C, especially because Hunter is a drug addict and still recovering drug addict. There is a provision in the application notes for those that are sentenced in Zone C, where you do not need to give prison if rehabilitation is really necessary in the case, and keeping the person out of prison in a rehab program would be much better and reduce recidivism and stuff like that. So, he most likely, in all events, regardless of whether it's a zone, regardless of whether his tax loss is over 250,000 or under 250,000, he's going to most likely get probation. More likely, obviously, if he can keep that tax loss under $250,000.
Yeah.
All of this, though, now just one quick point. All of this, though, may be academic, and we really should do a podcast sometime later this summer on what I'm about to talk about. Is if it's a binding plea agreement under Rule 11C1C. All of this talk about what the guidelines are, it kind of goes by the wayside.
Yeah.
If the parties can agree to what's called a binding plea agreement, and what what the plea agreement binds is the judge. And what the parties do in a C1C is they come up with a sentence. Okay, regardless of the guidelines, we think a sentence of 5 years probation or 3 years imprisonment or whatever it is. That's what we agree on.
Right.
If the court accepts the plea agreement, then the court is bound to impose that sentence.
Right.
So,
and
that may be the case here.
Yeah, that we're doing some guesswork because we haven't seen the actual plea. And so not only may there be some binding agreements, but what they do is they kind of craft the factual basis and sometimes limit the admissions or the things that are in dispute, so that in and of itself has some impact on the way the guidelines shake out. So, we'll have to see if there are any big surprises in the plea. And ultimately, the big question is, does he do any time at all? And it's either going to be the plea will make that clear because it'll be stipulated that he won't or that he will, which the judge has to follow or allow the parties to withdraw from the plea. Or it'll just be, we'll have to wait and see at sentencing time. And I got some thoughts on that. They may be premature, but just I think that kind of falls under this discussion we're going to have a little further down the road about whether equal treatment is happening, equal treatment with John Q. Citizen, who might have committed similar offenses, or equal treatment with Trump, who's in another high profile, politically connected figure that's in hot water right now. And I think it's not a stretch to say that there's some connection between what's happening now and with Trump and everything else. That's my opinion. But
one thing I will say, Doug, and this is empirically based, this isn't my opinion.
Yeah.
But both are receiving special treatment. Trump, as we noted in our prior episode, he got a notice of his impending indictment and was invited to come to court to be arraigned. Whereas most defendants charged something like that, like we talked about Reality Winner, they get a visit from the FBI and a bunch of marshals, and they get raided and arrested. They're
brought into court in shackles and chains.
Exactly.
They're not like, show up on Tuesday, we'll sort this out.
Right.
Yeah.
And so
but that said, and that's exactly, I'm sure, what's going to happen with Hunter. Absolutely. But
Hunter,
also,
though, he's pleading guilty. So this isn't unusual.
Far more common because they're playing ball. They're cooperating.
When you're playing ball, exactly. But as we're going to, I think, kind of segue into, it's this other information. Remember, two informations came down today. One was the 2 misdemeanors for the tax, and the other information, the felony gun charge.
Well, let's talk about that then.
Yeah.
So this is a really very sort of esoteric, little used in my experience. I've been in federal practice almost exclusively for over 20 years. Do you know how many times I've seen this charge come up in a case? One time that I can recall. One time. And it is a statute that is 18 USC 922G3, right? And what that is there are certain provisions under federal law that make you a prohibited possessor, meaning you're not allowed to have a gun because of this reason or that reason. And the most common reason is that you have a felony conviction. So I saw those cases. That's 922G1. It's the first one on the list, which is if you have a felony, you don't get to carry a gun anymore. Sorry, you lost the right.
Right.
And in the states, certain states have provisions where you can restore those rights. The feds don't. So basically the feds are the ones a lot of times that are prosecuting these cases. And I've gone to trial in these cases. I've actually won a lot of these cases for the simple fact that I don't think people like the fact that the federal government's trying to take your guns away. But that's another story. That's a very common, very popular, very frequently invoked statute under federal law. This thing that Hunter's got going for diversion is not. This is called a user or addict in possession of a firearm. Most people don't know this, right? That do you have a gun, somebody? Because I know that, apparently a lot of Americans do have guns. And you, John Q. Citizen, if you have a gun and you smoked a little pot last night, you don't have to be an addict. You have to be a user or an addict in possession. And it's a weird statute. And I argue that it's very unconstitutional. In fact, that one case I had a motion ready to file challenging and there is some case law in some jurisdictions it's just a bullshit statute, frankly. And like I said, never invoked. So you ran some of the numbers on it. Compare in the last 10 years the number of straight up felon in possession cases with the number of 922G3 user addict in possession cases. It's a big difference, right?
Yeah, it's a big difference. So in the last 10 fiscal years for the G1, which is the felon in possession, there were 55,841 cases that involved that statute. So there could have been other statutes of conviction, but that was at least one of the statutes. Whereas the G3, there was only 2,654 of those. In that time, in the last 10 fiscal years, there were 693,398 federal sentencings, and only 2,654, or 0.4%, involved G3, whereas 8.1% involved G1.
Yeah.
So it's very, very, it's rare. It's rare.
And I will say, when this was first bubbling up, the Hunter, and that he was being investigated and he might be looking at charges, the charge that I thought was most likely with regard to guns was a different charge than he's got diversion on. It's 922A6. It's called false statements in acquisition of a firearm. And this is because what happened was he wrote this book, and it was a true confession about the many things, but the nature and extent of his drug addiction. And he wrote in this book and the periods where he was using and when he was using and everything else. Well, guess what? When you buy a gun, you fill out a form. It's like a declaration. Are you a convicted felon? Are you a currently user or an addict, of illegal substances? And if you say no on that form, you have just violated 922A6. You've made a false statement. And I thought for sure that was going to be what sent him over. I didn't think it was going to be the user one, because again, it's just such a stupid. And we see the false statement one very, very often in federal court too. Usually it's in the context of the box saying, are you buying this gun for yourself? Because there's something called a straw purchaser, where I'm going to go in and buy a gun and say it's for me, but I'm going to turn around and give it to my girlfriend who's got 6 felonies. And she can't buy a gun. So I'm a straw purchaser. I lied on that form, right? And we see those prosecutions all the time. In fact, I think you ran you ran the numbers on that, and it's pretty small.
It's very small,
okay.
But I mean, again, that is, it's over a 10-year period over all districts. Now, maybe most of there was 1,934 overall over the last 10 years.
Yeah.
But those could be clustered in your district.
Yeah.
Down in the Southwest. Maybe You just don't see many in the Northern District of Ohio or in the
Right.
Western District of New York, but in the District of Arizona or the Central District of California, you might see a lot of these. So
Yeah.
just because there isn't a lot doesn't mean there isn't a lot in a particular district.
And so my question is,
Yeah.
okay, why this particular one? He probably could have had his choice of either of those. And as we're going to talk about, I think the guidelines are exactly the same. So the question is, why do they choose this user in or addict in possession? I think the answer is pure speculation. We don't know for sure.
Well, actually, I think
Yeah.
we do.
Okay.
I think as we started out, the tax offenses. I mean, is your question why is he guilty?
No, okay.
Oh,
So I
I'm
see what
sorry.
you're saying. It's
Okay.
not why did he plead to the tax and take diversion on the gun? I think
Yeah.
that's an easy one because the gun's
Yeah.
a felony and the tax
Right.
is a misdemeanor.
Right.
And but it's why did he plead to the user in possession instead of the false statements on a form? Because false statements on a form sounds, if it's the same guideline and it's diversion anyway,
It's the same guideline.
it sounds a little bit better than you're a crackhead and you shouldn't have had a gun. So it's either the government wanted to tell that story or the defense wanted to, because it fits their narrative that, he went through this addiction, he's reformed himself, and these were bad mistakes that he made, and he's owning up to them. And this is all drug addiction is underlining, animating all of this. So please, it's okay. Let's focus on that because I wrote a book on it, But I just thought it was really, really interesting that is the one that he does. But whatever, I guess that's probably one of those things that's more interesting to me than most normal human beings. And so I'll move on from that, but let's talk about diversion, because I think a lot of people don't understand what that is. So what is diversion? What does it mean?
Well, basically what it is delayed prosecution. So at the beginning of a prosecution, you enter into an agreement with the government to, if you're a drug addict or something along those lines, like Hunter, you agree to enter into a program, generally for rehabilitation and whatnot, for a certain period of time. And if you successfully complete that, then that charge that's been lobbied against you ends up getting dismissed. At least that's the way it works in federal court.
Yeah.
The problem, though, is even with diversion, that can still come back and be counted as criminal history in some future case. But I might be getting too much into the weeds.
Hunter's not going to get in any future trouble.
No, he's not going to get. But it's really interesting, though, that this came down today, and that a part of Hunter's plea agreement to resolve all of these issues was to enter into a pretrial diversion program. The reason why is just last week, the U.S. Sentencing Commission published its proposed priorities for the new amendment cycle, and one of them was to look at developing more pretrial diversion programs and getting judges to really encourage those, and U.S. attorneys' offices to develop them. Each U.S. attorney's office is responsible for its own pretrial diversion program. And not all of them have them. And many that do have them, they're kind of moribund if they're being used at all. And
well, I can give you my take on that, because I've seen a lot of this all over. And first of all, it should be of note that in one of Merrick Garland's recent memos to the DOJ at large did say that you guys should start thinking about diversion more than you are, because it is in certain state jurisdictions, it's extremely common, especially for low level like drug cases and things like that. But in federal court, it exists, but it's a rare, it's a unicorn in a lot of things. I've been able to get them in limited situations, and there's variations on the theme by district. So for example, here in Arizona, I rarely see a straight up diversion, which means we're just going to put this in a drawer. You're going to be on some supervision. If you get through, follow all the rules, this is going to get dismissed. Everything's cool. What they do instead is called a deferred sentencing. So they say, you're going to go to court. You're going to enter a guilty plea that you committed this crime of user and possession of a firearm. And if you, then you're going to go on supervision. If you get through, we will then dismiss that. But if not, you're going directly to sentencing, do not pass go.
Right.
You're done. And that way they're not jerking around with, okay, now we got to figure out, what are you going to plead to? Or, you know, are you going to go to trial on this? Do you have a thing? You know, so there's that too. And then they have another weird form, which is diversion, but you're going to plead guilty to this felony. And if you get through, it's going to drop down to some other kind of misdemeanor. So we're still going to tag you with something on the way out the door.
Yeah.
But they would, you know, so there's variations on the theme, but I think the main takeaway, this is a very rare bird. So I want to ask you, Hunter got a very special thing that'll,
Yes.
in this diversion, because he'll be able to keep his felony record clear. He'll still be able to vote for his dad, and he might be able to carry a gun to the polling station. Not take it into the polling station, but at least he still gets to have a gun.
Right.
So
Well, let me give you some. Let me give you
special
some
treatment.
Yes, he's getting some
Oh.
very special treatment.
Surprise, surprise.
Some exceedingly special treatment. So
Okay.
first of all, just as you noted, pretrial diversion is not widely done in federal court. Since, according to my research, since 1982, there have only been, and we're talking probably 2.5 million defendants that have been sentenced federally since 1982. And that's going back before the guidelines. Only 8,360 dockets contained any mention of pretrial diversion. And that doesn't mean that all of these individuals or the defendants in these dockets received pretrial diversion. Very often, there will, what I discovered, there will be notes between the parties that they're asked for a continuance because defense counsel wants to negotiate with the prosecutor about whether the client can enter pretrial diversion or not, and nothing comes of it. And the defense counsel or the government says no, or something along those lines. So it's very rare, 8,360. And out of those cases, I know how many by district. And the big districts that had these, and this is going all the way back to the 80s, by the way. California had the most with 1,278, which really, again, is not that much considering how many people have been.
Since for how long is that again?
Back to 1982.
Oh my
Now
God.
the bulk of them really started. It really started around 1993 is when it really started to pick up, and it maxed out 97 through 1999 and stayed kind of steady through the 2000s, and then right in 2015 the number of dockets having pretrial diversion cases on them, or pretrial diversion mentioned in the docket, started to drop off dramatically starting in 2015, and has continued down. Right now we're basically back at mid 1990 levels.
Wow.
So something happened where pretrial diversion has kind of got dropped off everybody's radar.
And that's not just California, that's nationwide. You're seeing that drop off, right?
Yes, nationwide. That's nationwide. But again, California has had the most, but it's still not much. 1,278, followed by the District of Washington, or all the districts. And by the way, when I say California, I mean the 4 districts in California. They've had the most, and the 2 districts in Washington had the second most with only 1,083. Hunter is being prosecuted out of the District of Delaware. Since 1982, there have been only 15 dockets even mentioning pretrial diversion.
Wow.
Since 1982.
So he's one of a very select few.
He's one of a very select. Now, there's another way to look at this. So they've only had 15 in the District of Delaware. If you look at his charge, 922G3,
yeah,
nationwide, there have been only 18 dockets involving pretrial diversion. And
Since 1982?
Since 1982, none in the District of Delaware. This is a first for that district.
I'll do my best church lady impression. Well, isn't that special?
Very special.
That I think when you look up special treatment in the dictionary, it says, see what you just said.
Yeah.
There's a picture of Hunter Biden in there.
Yes.
So you know what? I'm not going to ask people how to feel about that. I'll let you make your own decision, but I will say this. The only takeaway that I can offer for people who do this work or who may be in a little bit of trouble is ask for fucking diversion.
Yes,
we don't do it. We don't ask for it a lot, either because I think maybe lawyers don't know it's a thing because it's so goddamn rare.
They don't.
Or because they just think, oh, I'll never get that. You're never going to know until you try it. If you tell a good story around it and make a good case for it and do your homework, you will get it. I've gotten diversion in 2 cases in the last 2 years. Okay. So is that a lot? No, but I've asked for it in many, many other cases. And sometimes I get it and sometimes I don't. But let me tell you something. If it's good enough for Hunter, it's good enough for you. Merrick Garland says, let's do this more. So let's do this more. The commission, you said, just says, let's do this more. So let's do this more. I'm telling you, this should be given way more than it is now. So let's work on that.
And for the attorneys out there, make sure to look at the U.S. Attorney's Manual, which is available online for free, and it's section 9-22 that covers pretrial diversion programs.
Yeah, I'll put a link to that in the show notes too.
Yep, and there's selection criteria in there as well.
Yeah, ask for it. Why not, man? Why not? Yep. So my dog is weighing in. That's probably dinner time for him. But anyway, well, we do have to do one more guideline calculation, which is worst case scenario. Hunter, I don't know, falls off the wagon or gets something happens and he flunks out of diversion. He breaks enough rules of supervision and they pull his diversion plea, which they would be legally allowed to do. Yep. And this charge is back on the table and he ends up being convicted of this felony gun charge. What do the guidelines look like then?
Okay, so if he's going to get convicted of the felony gun charge too, so that's going to go to 2K 2.1, and he's going to start out with a base offense level of 14, 2 off now because it's only starting out at 14, so he's only going to get 2 off for acceptance. That's going to take him down to 12, and also assuming he gets the Zippo. He would not get the Zippo if he gets convicted of this because of criterion 7. Criterion 7 in Zippo says if you even possessed a gun, you do not get the Zippo. So he would start out at 14. He would only get -2 for acceptance. That would take him to 12. The problem now, going back to the tax, what we said there, he's going to start out, and we're going to assume worst case scenario. We're going to assume tax loss is over $250,000. So he's going to start out at an 18 -3, and that's it, because he doesn't get the Zippo now because he's been convicted of the gun charge. So -3 is going to take him to a 15. So he's going to have 15 for the tax, and what did I say? 13 for the gun. So I'm sorry, 14 -2, 12. 12 for the gun, 15 for the tax. These don't group. So these are going to be treated as 2 different offenses for purposes of the guidelines. Because there's 2 different ones, he's going to get an extra level, and you're going to take the higher of the 2 groups, and you're going to add 1 level to that. So the higher of the 2 groups, again, is going to be the 15 for the tax loss. He's going to end up at a 16 if he's convicted also of the gun charge, because again, he's going to lose the Zippo, and the 2 offenses don't group. So at a 16.
Well, by the way, before you do that calculation, let me add the criminal history rub, because what if he gets sentenced to the misdemeanors tax things and then goes on diversion and then flunks out of diversion and he's already been sentenced on those tax? Could they use those to bump criminal history up?
Yes, because and the reason normally the answer would be no, but because these 2 offenses are distinct, And the gun charge has nothing to do, ostensibly, with the tax charge. Two different offenses. So yes, now those misdemeanors are going to come in, but I think he'd only get 1 point. So it may not change.
1 point for both because they're
1 point
basically
for the
connected.
tax. No, 1 point for
One-
the tax. If he gets hit with the tax first and then he's sentenced
Yeah,
later.
but it's two charges for the tax, but you're saying he only gets
No, it'll just be
1 point
because
for-
those counts group together.
Okay. So
Yeah,
he'll only have 1 criminal history point under that scenario, and that would not
Well,
bump him up.
well, he could have more. He may end up with 2 because if failing the if he fails the pretrial diversion, and that also constitutes as a violation of his terms of probation for the misdemeanor stuff, that's going to be another point.
Yeah. Okay.
So that's going to take
that's
him.
interesting.
Yeah.
That's assuming he even gets supervision for the tax stuff. But I guess this is more pin dancing on the head of a pin.
Yeah.
But
Well,
there's little landmines that we have to look out.
So anyway,
for.
so point is he would have 16 at the end of the day.
Yeah.
And that's bad because now he's in zone D,
Uh-huh.
and in zone D, prison is required, at least under the old version of the guidelines, even though that terminology is still in there. They need to really you need to update this commission. It's been like 100 years since Booker passed at any rate. At 16, that's 21 to 27 months. And by the way, if he's convicted on that gun charge, what is that, a 10-year stat max? Mm-hmm. So now, I said before, if it's just those 2 misdemeanors, he's only looking at a 2-year overall stat max.
Yeah.
But now with that, the gun charge, it's up to 12 years.
Mm-hmm.
And so,
and he's a felon at that point with all that.
He's a felon.
Yeah.
So all the collateral consequences, and he's looking at 21 to 27 months. And so what does Jason tell us for 2T1.1? And we're going to assume just criminal history 1 to make it a little easier on everybody.
Jason, by the way, if you didn't hear that podcast, I'm going to put that in the show notes too, but it's judicial sentencing information. It's a database that where you can do some quick stats on these sentences. So what's Jason got to say about all this?
Jason has said for the last 5 fiscal years, there have been 15 defendants sentenced under 2T1.1 with final offense level 16 and criminal history 1. The average sentence was 10 months.
Okay. So yeah, if he flunks out a diversion, his chances for prison go up exponentially.
Yes.
A lot. But let me ask you just your opinion. Let's say he's cool on diversion. He's Joe cool. He gets through it, follows all the rules. He's just being sentenced on these 2 misdemeanor tax counts. Do you think this guy gets any time in prison for this tax?
No, I don't think he'd be getting any time. And what's important to understand is that he's not going to be getting a slap on the wrist because nobody gets time for 2 tax misdemeanors. The vast majority get a day or less. He may end up getting 1 day in prison, and that's just to get him onto supervised release. But he's not going to do any time for this, just like everybody else. So he's not going to get any special treatment in that regard. The pretrial diversion, very special treatment. The fact that he's avoiding a felony conviction, very special treatment. But the fact that he's not going to do any time for these tax offenses, no special treatment at all. Very typical.
Interesting. So I think I agree with you, but I'm not sure. And here's why. And I mentioned this before. I do think there's a connection between Hunter's case and Trump's case, which in that, and maybe I'm crazy, maybe I'm wrong, but obviously this whole "what about Hunter" thing has been pervasive on the right forever. And they're saying it's not equal treatment because Trump gets charged for every little thing, and look at Hunter and Burisma and the bribes and the crack and the guns and the laptop and what about. And so the question is, if Hunter Biden's name was John Q. Citizen, would he still be being pursued and prosecuted by the Department of Justice? And because these are minor tax violations in the grand scheme of things.
It'll be
And
civil. It'll be
and
civil.
this, like I said, this drug thing is so damn rare, and it's
Yep.
just, I believe in my heart of hearts that there's a utility to targeting Hunter and holding him accountable for something, because
Yeah.
they think that is going to make them look more fair and even-handed, that nobody's above the law. It doesn't matter if your name's Biden or Trump. And if they're going to do that, don't they also have to then well, let me put it this way. If their aim is to pursue a conviction to Trump to the end of the line that lands him in prison, if that is their goal, and I don't know that it is, I think given the severity of what he's charged with, it should be. But
Yep.
if that's their goal, don't they have to pursue some time against Hunter to keep up with this and nobody's above the law kind of thing? Because, this whole case, arguably, we can say is being done to shut those detractors up and say,
Well,
nobody's above the law, and nobody's above going to prison, no matter what your name is.
Well, to just speak guideline nerd speak for a second, what
Yes.
you're talking about is unwarranted sentencing disparity. And usually what we do when we talk about unwarranted sentencing disparity, we just look at the offense of conviction,
Right.
and not so much the offender.
Right.
And
Which is
here-
what you're basing, you're saying he's not going because you're looking at similarly situated offenders with these tax charges
From
and they don't go.
from the offense of
Yes.
conviction, correct?
And I'm telling you, in this case, there may be a whole different calculation in play.
Based upon the offender, and that's correct. And that's what I'm saying, is that what you're talking about is looking at the offenders as opposed to the offense.
Yeah.
There may be a disparity here if Hunter doesn't get any time and Trump does, be given the political nature, and they're both tied to a current campaigns. Trump's running, Biden's dad is running, so there is a disparity there when you're looking at just the offenders as opposed to the offenses. And that raises an interesting question about how important, how should a judge weigh that then, assuming that Hunter's judge is not bound by a plea agreement, and which, even if there was a binding plea agreement, the judge could dismiss it, and that has happened when a judge is presented with a binding plea agreement, and the judge doesn't think that there's enough of a sentence here, or what the agreement is doesn't represent the offense conduct or the offender, could reject it. So, and that raises finally actually one last really big issue, and it's not theoretical. I think it's a real issue. If they both end up going to prison, Hunter and Trump, where are they going to be housed? I mean, they both have Secret Service details. How is that going to work?
Yeah. Oh, well, I'd hate to be the warden at that institution.
Oh, yes.
But that's, and just back to that thing. If Biden ends up doing prison just to satisfy the what about people, and why, that's a bad result. If the goal is to satiate that crowd, and feed the beast and send him to prison to satisfy them, I got news for the DOJ, and they have to know this. That's not going to satisfy anybody.
Agreed.
If
But
their
I guess
goal is to feed that beast, that beast goes to sleep hungry tonight.
Yeah.
And I guess my last question, you raised a fun one about where does he go to jail with the other guy? But hey, arguably his dad is still president and has the pardon power after this plea. Does Joe turn around and just pardon his son lickety split?
Well, we know Trump would if it was Don Jr.
100%. He would already be pardoned. He'd be pardoned the minute he pled guilty, probably.
Yeah. Well, you and I both know that Biden would never do that.
It's a little different.
Yeah.
What you're saying is he does things a little bit differently.
He does things a little bit different from at least from what I can tell.
Okay.
Yeah.
Well, I'm sure that point won't be lost on the far right, who's screaming for blood right now.
And by the way, what I will say though is this plea agreement kind of is an effective pardon, because misdemeanors, big deal. It's the
they don't
felonies.
alter your life in any
The
meaningful way.
felonies are the ones that alter your
Yeah.
life. The felonies are. So he
Yeah.
kind of is getting a pardon. He's getting a pass.
Yeah. And people need to understand that even if you don't go to prison, when you get tagged with a felony, it does alter the course of
so many
your
collateral
life.
Consequences. Yes.
Basically irreparably alter. Even if you get a pardon down the road, it's still not a good thing. It's not a good thing. So good for him. It's a good deal. He's got a good lawyer.
Yes, he does.
Whoever represented him, nice work. And I have no doubt that his client will do what needs to be done to put this in the rearview mirror. Hey, you want to do a little trivia? We talked about this felon in possession statute, but I still have it up just in case anyone listening who's got a gun wants to know what else can get you charged with a federal offense. Don't be a fugitive from justice, and don't be adjudicated mental defective. Don't have a domestic violence offense in your record, even a misdemeanor. Don't be here in this country unlawfully. That's not good. Don't be discharged from the armed forces under dishonorable conditions.
Yes.
Can't do that. If you're a citizen and you renounced your citizenship, no gun for you, mister.
Yep.
Let's see here. Subject to a restraining order. You don't even have to be convicted of a domestic violence. If your girlfriend's got a restraining order out against you because you drank too much tequila and trashed the place, you're a prohibited possessor if you've got a restraining order against you.
But Doug, sorry to interrupt you, but you do realize that a lot of this is getting struck down on constitutional grounds.
Well, I realize that there's been some jurisprudence in the highest court of the land that might call some of these into question, but have there been
in the Third Circuit?
Have there been legitimate provisions that are no longer in effect? I guess that's a whole other podcast, but
it's a whole other podcast. But yes, the Third Circuit has struck down a couple of these, and
well, I would simply encourage, and I'm being a little flip, but I do see these cases all the time where someone gets charged and go, I didn't know I wasn't allowed to have a gun. And guess what? That's not a defense. So I would encourage any of my loyal listeners who are interested in guns to take a close read at 18 USC 922G. The whole list is there. And, just make sure you can have that gun lawfully, because we wouldn't want you to run afoul of federal law.
Yep.
Yes. Well, gee, this has been fun. I'm so glad we got to do an encore get together. Thank you again for all of your help, as usual.
Well, thank you, Doug. This was fun.
It sure was.
Yep.
Talk to you soon.
Okay.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.